2, 1. All right. Hello and welcome. Hello and welcome. Welcome to another episode of the Empowered Immigrant Live. My name is Otis Landerholm, and I'm so happy to be here with you live today. It is the 10th of September of 2024, and I'm happy to be here. We're rolling live on Facebook, YouTube, LinkedIn, Instagram, TikTok. So welcome, everyone. Thank you so much for being here. I want to give an update this morning on the Biden Parole in Place program for spouses of U.S. citizens, the Keeping Families Together Parole in Place program. So we'll do that, and I'll welcome any questions that you've got as we're going, and we'll have a conversation here today. So if you've got questions, we've got answers, or we'll do our best to answer any questions that are out there. Please feel free to submit them. Thank you all so much for being here. And so, yeah, welcome, welcome. The Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? And so thank you, welcome. We'll do this episode in English first, then in Spanish. If you prefer Spanish, join us in about an hour, and we will do the same episode in Spanish. Today, our theme is an update to the Biden Parole in Place program for spouses of U.S. citizens, the Keeping Families Together program. So tune in, join us, tell us or ask us any questions that you have. Tell us what questions you have. I'll do my best to answer them. My question always is, hey, do you want to get a green card? Do you want citizenship? Do you want to come out of the shadows? Do you want to see what your options are? Do you want to at least see what your records are related to your immigration situation? Whatever that case may be, go for it, all right? Improving your immigration status can improve the quality of your life. And my firm is on a mission to win 10,000 immigration cases in the next 10 years. We would love for your case to be one of them. And so thank you for joining me. Thank you for being here. Again, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Thanks so much for being here. So we got news. All right? We got news. The Biden Parole in Place, which I'll be discussing today, there's a pause in place. There's litigation filed. The pause was originally set to end yesterday, and then it's been extended, all right? So the real update is it has been extended until the 23rd of September, and we're going to see what happens. The litigation's continuing in Texas. We're going to see what happens there, all right? We'll discuss more about that. The other piece of news, which I want to share about, is, we got the debate happening tonight, Kamala versus Trump. Immigration is going to come up a lot in this debate, is my guess. And I want to give you guys an update into what the candidates are saying regarding immigration, and I'll do my best to give out an update, hopefully tomorrow, or if not, during our live session on Thursday morning. And so stay tuned for that. We'll talk about what the candidates really are saying as they debate each other this evening. A lot is riding on this election, folks. Can you feel it? Can you feel it? A lot of tension, a lot of frustration on both sides of the aisle, a lot of disagreement, right? There's just a lot of disagreement. And anyway, I don't know. There's always some excitement in the air too about it's kind of like a boxing match. It's like who's gonna win this thing? We'll find out in November, right? So all right. So let me talk about this parole in place. Lots of folks have already submitted their applications. Lots of folks already understand the parole in place. This was announced back in June, all right? And there's 5 requirements for it. I'm going to go through them briefly. We'll talk about the program, all right? If you've got questions about this program, feel free to submit them. If you've got questions about something else, feel free to just let me know. The 5 requirements are that as of June 17th, number 1, as of June 17th, 2024, you must have been married to a U.S. citizen. All right. 2, as of June 17th, 2024, you must have 10 years of continuous physical presence in the United States. All right. We had a potential client come in with documents showing that he arrived to the U.S. in July of 2014. Well, if you arrived in July of 2014, you cannot have 10 years of physical presence, unfortunately, because June 17th of 2014 through June 17th of 2024 are the 10 years we're talking about, all right? So those 10 years, that's literal 10 years, and that's the second requirement. The third requirement is you cannot have been lawfully inspected, admitted, or paroled into the United States. The fourth requirement is you cannot be a threat to national security, public safety, or have disqualifying criminal history. And finally, number 5, you must merit a favorable exercise of discretion. Those are the 5 eligibility criteria for this parole in place process. All right? Who does this help? There's lots of different estimates out there. The main one from the Department of Homeland Security is that there are 500,000 spouses of U.S. citizens and approximately 50,000 children of those spouses, so stepchildren of U.S. citizens, who are eligible. That's 550,000 people who are potentially eligible for this program. Okay? So if you apply for this program and if you win, then in theory you'll be eligible to adjust status in the United States as long as you are quote-unquote admissible. Okay? Without leaving the U.S., you don't have to do it through the I-601A waiver process, which saves a lot of cost, saves years of the delays that are enormous inside the waiver process. It's great news for everybody that qualifies as long as this thing actually goes forward. Okay? And which means, of course, that if you're not eligible for this parole in place, for example, because you don't have the 10 years, or for example, because your spouse is a lawful permanent resident instead of a citizen, something like that, then the way to do it is to go through the waiver process and the consular case as if you weren't lawfully inspected and admitted into the country originally. Okay? Now, you've also got to show you've got a legal and bona fide relationship with your spouse, and you've got to show that you were admissible or are admissible, which means no fraud, etc., to get your green card, or eligible for a waiver of any inadmissibility ground, right, in order to adjust status. Okay? If you're not admissible, if you're not eligible to adjust, but you are eligible for parole, there are a handful of folks. Hey, lawyer, I've got a permanent bar. Hey, lawyer, I've got a false claim to citizenship. Talk it through with a lawyer carefully. Right now, this whole thing is paused anyway, right? Right now, this whole program is paused anyway until the 23rd of September, and we're going to see what happens after that. And in theory, if you're eligible for parole but not eligible to adjust, then the parole would basically get you a Social Security card, a work permit for 3 years. All right, and we're going to see who wins the next election. We're going to see what the candidate who wins the next election's policy is about this parole program. In theory, if Kamala wins this election, it could be a renewable program. All right? And in theory, if Trump wins this election, then this program's going bye-bye. All right? And so that's the reality. That's what is very likely the reality. What's the process? All right, what's the process? Well, there's a $580 filing fee. There's a USCIS online account you have to create. Upload each of the years of physical presence evidence. Upload evidence of who you are, your birth certificate, your passport, whatever identity information and evidence you have. Basically upload all the eligibility factors, fill out the form, the I-131F form, submit it online, review it with your attorney first, submit it online, get a receipt, and then it's going to be pending. They can't issue decisions right now. It is paused right now. But you can get a receipt, and then you just have to wait to see what's going to happen with the litigation and what's going to happen, whether or not there's going to be a decision. Okay? So my office has submitted several of these applications, and they're pending, right? And we're going to see what happens. And obviously, there are risks involved, right? Because, it's possible that this doesn't go anywhere. It's possible that the litigation happens and the judge says, nope, this is an unlawful use of government decision-making, and, they didn't follow the Administrative Procedures Act, or, there's some other violation that the judge in Texas might find to say that this is unlawful. Now, arguably it is lawful, right? The government does have the power to grant parole. We've seen lots of different parole programs that have been just fine. And parole in place is one of their powers. And so, arguably there is a case for this, and we're going to see what happens with this. But nevertheless, right, this is like, the other risk is the November election could undo it completely. And so, and I think everybody's on the same page about that. There are some clients that I've said, hey, in your situation, you might be wise to wait until the November election first and then make a decision. Now, in other cases, it's like game on. There's no harm, really. There's no harm in filing this, because if it's approved, great. You'd be eligible to adjust status. And if it's not approved, okay, now we move forward with the consular case. No harm, no foul, right? So that's a lot of the advice that I've been giving to people about this particular program. It's like, lawyer, help me understand the risks for me. And that's something that we talk through in a consultation. All right? So like, lawyer, what are the risks? Let's talk it through for a second. All right? So if you're otherwise eligible for an I-601A waiver, if you're otherwise admissible, and the only issue that you're facing is unlawful presence, then, and if you don't have a deportation order, you don't have serious immigration violations in your past, then the risk is low, right? If you're otherwise eligible for an I-601A waiver in a consular process, then the risk of doing this process is low. But you got to know, right, that when you submit this, you are submitting your information to the government. You're submitting information to the government that you're in the U.S. in violation of immigration laws. And so that's where it's like, okay, if Trump were to win, and if the enforcement priorities were to change, that's where the risk could be greatest. And you got to be aware of that. And part of our job as a quality immigration law firm is to give people quality immigration advice about the risks, the benefits, the pros, the cons in any person's given situation, so that we can help mitigate the risks, right? And so that we can make well-informed decisions. All right? And if you've got other inadmissibility grounds, fraud, crimes, alien smuggling, unlawful presence, more, it's like you want to talk it through very carefully with your lawyer first. Have a consultation first, right? So you can really be informed. Okay? Obviously, the most complicated cases, permanent bars, false claims to citizenship, deportation orders, crimes, if you're currently in immigration court proceedings, etc., right? Those, in some of those situations, for example, if there's a deportation order, the regulations say that there's a quote unquote rebuttable presumption that you're not going to be eligible for this parole. All right? Certain crimes just make the parole impossible, right? Make it that, like if you have pending criminal charges, etc., they just say, no, you're going to be denied. So in cases like that, don't apply. All right? But it's like, you really want to talk it through with a lawyer. Anyway, as I mentioned at the beginning, the parole in place is paused. All right? It's paused, right? And we're going to know more after the 23rd of September. And so if you want to know more, if you want to understand more at that time, hey, please follow our channel. We will be giving all kinds of updates as this program moves forward, as the litigation moves forward, and we're going to see what happens. Okay? So, and there's like 10+ million people who are not eligible for this program anyway. And so for the folks that aren't eligible for it, well, let's meet and discuss other things. What might you be eligible for? Is there a possible U visa or asylum or family-based immigration options or immigration court options? T visas, U visas. There are other things that can be done. And so, that's part of what immigration lawyers are here to help you with. Okay? So what can we do for now? What's the best advice right now? Really, the best advice right now is first, let's get clear on your situation. All right? Let's get clear on your situation. Sometimes we want to request, review all of your records first, your FOIAs, and determine what's the best strategy for you. I definitely recommend everybody do that, get that done before the November elections, because you want to know. All right, you want to be prepared. You want to have a game plan, and if you don't have a lawyer, I think the time is now. It'd be recommendable to get a lawyer, just in case you're going to need one. All right, to help you figure out what your options are, help you figure out what the best strategy will be for you to fix immigration status long term. That's the best way to do it. All right. So I'm seeing some folks here. Thank you all so much for joining. If you're just now tuning in, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. And, we fight for the rights of immigrants. And so thank you. Thank you for tuning in about this. So Christopher Carbajal, I see you here. Good afternoon. Great to see you. Still morning where I am, but good afternoon to you. All right. Joao Marcos da Silva, hello, good afternoon. You say, tell us about motions to reopen and motions to expedite for people who have unexecuted removal orders. Thank you. So, okay, we can talk about motions to reopen. So if you have a removal order, like imagine you entered the U.S., you filed for asylum, and then you lost. All right. Imagine that's the situation. Well, if you're in that situation and you lost and a judge says no, for whatever reason, they don't think you meet the legal definition of an asylee, they're going to deny your asylum case. Now they issue an order of deportation. All right? That order of deportation can be appealed. All right? While it's on appeal, it's not a final order yet. All right? If it's denied on appeal, it can be appealed again. We call it a petition for review to the circuit court, depending on which federal circuit you're in. All right? At the circuit court level, if you lose there, typically, there's a minor, very, very slim percentage of cases that go all the way up to the U.S. Supreme Court. Most of the time, that doesn't happen. So typically, at the circuit court level, that's the end. All right? Then if that's where you're at, or if you didn't appeal it all the way up, then now you have a final order of removal against you. So if you've got a final order, right, but if you haven't actually been removed, then you have what's called an unexecuted removal order. It's unexecuted because the government hasn't come and actually executed that order, hasn't actually caused someone or removed someone, deported someone from the U.S. So when you're in that ground, you're here in the U.S., there are thousands of people. I've got lots of clients in this situation, all right, where you're in the U.S. and you have a final removal order, an order signed by the judge saying that they can deport you. When you're in that situation, you could, in theory, file a motion to reopen your case. Okay, that's what a motion to reopen is. You're filing a motion to reopen that case. You cannot file a motion to expedite, all right, if your case has already been heard. And a motion to expedite is, if you have a valid open case right now, let's move the court to hear your case quicker. All right, that to expedite, to move your hearing dates up. All right, motion to advance, motion to expedite. But a unexecuted removal order can be reopened in certain situations. And it's been a while since I've talked about all the real reasons that the immigration court could reopen proceedings. All right, and so and all the different deadlines involved. There's like 7 major reasons, major like laws that allow the immigration court to reopen immigration court proceedings. I could do a whole live session. Maybe I'll schedule that, actually, create a whole live session on that. But the most common one right now, all right, let me share about this. Right now, under the Biden administration, there are enforcement priorities, and there is what's called prosecutorial discretion. Has everybody heard that term? Like maybe put a yes in the chat or something if you've heard of PD or prosecutorial discretion. What prosecutorial discretion means right now, everybody, is that the government is willing to exercise their discretion. The government is the prosecutors, la fiscalia, normally the bad guys in an immigration court case, right? But what prosecutorial discretion is saying is that in their discretion, they're able to join a motion to reopen, all right? Or in some cases, if it's not at a deportation order stage, in some cases, they're in their discretion willing to join a motion for administrative closure. Or in some cases, they're willing to not issue a notice to appear in their discretion, right? They can use their discretion at various points of the process, including whether or not to, quote unquote, join a, quote unquote, motion to reopen your case, to allow you to fight your case, file for asylum, file for some other immigration benefit, maybe through your marriage to your U.S. citizen, for example. Anyway, Marcos da Silva, that's a long answer to your question, and we can talk more in depth about it. The best way to really go into your situation is, hey, let's do a consultation, let's request and review all of your records, figure out what caused that deportation order to begin with, and then see if there are arguments to attack it. Like for example, everybody, you can do a motion to reopen if your previous lawyer really messed up. All right, we call that a motion to reopen based on the ineffective assistance of counsel. And, there are ways to do that. I don't know if you knew that, but there are ways to do that. And so sometimes when we review the records, we got to look at that. There's also motions to reopen in the asylum context for changed country conditions based on your home country. So anyway, we could talk a lot about motions to reopen. My next question here is from Illust Lost. Illust Lost. Thank you for your question. You say, I've got a question. If they are trying to deport me despite my having papers in order, what can I do? Well, great. 1, talk to an immigration lawyer if they're trying to deport you despite your having papers in order. And 2, you can file a motion to terminate, right? Like if you're in court in front of a judge, and if the judge, if you're like, hey, let me tell you guys a story. let me tell you guys a story. This happened, I was a pretty new immigration lawyer. I was sitting waiting for my case to be called in the back of the court. All right, in the back of the court. And there was a client, in a master calendar hearing, there's 50 people in the courtroom. Every person comes up with like 5 minutes in front of the judge. All right? There was a kid. He was probably 18 or something. He was in deportation proceedings. All right? The judge calls his case. He walks up. He shows his U.S. passport. He's like, Your Honor, I'm here. I don't have a lawyer. I'm just here. But I'm a U.S. citizen. Here's my passport. I don't need to be here. The judge takes a look at his passport and he says, okay, we're going to terminate your case. You won. You're right. You don't need to be here. All right? Like, that's the easiest motion to terminate in the world. In other words, illust lost. If you're a U.S. citizen already, if you've already won all your status, then congratulations, you're going to have an easy motion to terminate. Okay? And if you maybe have a green card or something less than U.S. citizenship, then okay, you might have a fight on your hands, because even though you've got your papers in order, there might be an allegation that you've violated the terms of your immigration status. And so that's something that you're going to need to lawyer up about, because sometimes that fight is a fight that comes in front of the immigration judge. All right, my office has plenty of clients in that context. All right, Vanessa, I heard there was a hearing on PIP scheduled for the 18th. I don't know the specifics. Do you? Okay, so that hearing, yes, you're right. All right, that hearing is what we're going to be tracking, and we're going to be following up, because they've made a stay of the parole in place until the 23rd. That hearing is on the injunction, and it's going to see whether or not there's going to be a quote-unquote permanent injunction or a permanent stay during the rest of the litigation. All right? So yes, after the 18th, I mean, it's really, the 18th is just the hearing. They're not going to have a decision yet, right? We should have our next decision based on what happens in that hearing and the briefings, et cetera, that are happening before the 23rd. And so that's what we're going to find out. Okay? Anyway, I hope that's helpful. There's a lot of uncertainty, right? It's really going to be up to the judge about how they analyze whether or not to maintain a permanent stay while the rest of the case and the evidence and everything else gets decided. Okay? Hope that's helpful. So Bonnie's Bouquet, I see your question here. You say, I'm on a U visa with bona fide determination on the wait list. I'm married to a U.S. citizen with an I-130 approved, but I was expeditedly removed at the port of entry in 2007. How can I adjust? Please advise. Okay, I got that. So let me ask you a question, because here's the thing to keep in mind. If you were expeditedly removed in 2007, like you were at the border, they issued a deportation order, and they removed you, and then after that you re-entered the U.S., is that correct? Like right now you're in the U.S., right? Right? And so when a person has an expedited removal and is removed and then re-enters, what that actually creates is it creates a permanent bar. It creates a 212A9C problem. Okay, we call it the permanent bar. It's a 212A9C is the immigration code section. And so Bonnie's Bouquet, the problem that you've got, and I hope that your U visa was done well, all right, and I hope your U visa included the waivers to waive all of this. The U visa can waive it, but your marriage can't, okay? And so if you're in the situation that thousands of my clients are in, hundreds, probably not thousands, hundreds of my clients are in your situation too. Expedited removal order, re-enter the country, it's a permanent bar. all right? A marriage-based case cannot fix a permanent bar, but a U visa can. It's one of the powers of the U visa. And so your U visa is the right strategy. If your question is, how can I adjust, please advise, the answer is you can adjust through the U visa, but not through your marriage. All right, and I'm sorry if you haven't been fully informed of that until now, but that's the truth. And you should verify that the facts as I understand them are the facts in your situation. Like, were you given an expedited removal but then paroled into the country, and then it was an unexecuted expedited removal order? That happens sometimes. All right, that happens sometimes, specifically when people pass a quote-unquote credible fear interview is where that happens. And so you might want to request all of your FOIAs and look through them very carefully with somebody who knows what they're doing, right? But the vast majority of the situation, 95% of the time, you've got an expedited removal order, you were actually removed, then you re-entered after it, that creates a permanent bar. Now you're not eligible to adjust through a marriage, so now the best advice is to use the U visa. That's what the U visa is. That's one of the huge benefits of the U visa. Anyway, hope that's helpful. If you have questions, please feel free to contact my office. We'd love to review those records and give you that advice. All right, user 8850666, not 19, long name there, long username. Mis papás son residentes y yo no, ellos me pueden pedir. Okay, my parents are lawful permanent residents and I'm not. Can they petition me? All right. The answer is yes. Lawful permanent residents can petition for their children as long as you are not married. Si usted no está casado, la respuesta correcta es que sí, le pueden pedir. All right? So the truth is, if you are not married, your parents can petition for you. The real question is, can you use their petition? La pregunta principal es si usted puede utilizar la petición de ellos. All right? And to know that, we got to do a consult. We got to understand your situation, not their situation. All right? Are you in the U.S.? How did you arrive to the U.S.? Did you arrive with papers? Are you currently in immigration status? Like, we got to know all of these things. Otherwise, like, if the answer to all those questions is no, if you're outside the U.S., then no problem, right? Your parents can petition for you. If you're underage, it's a relatively quick case. We got to know how old you are, too. If you're over 21, it's a long, slow process, right? Anyway, yes, there's things that can be done. If you're inadmissible, though, you're not going to be eligible, right? In most situations, depending on the inadmissibility ground, right? Unless you're eligible for a waiver. Okay, worst behavior 811, and then I've got a question from worst behavior 811, and then I've got a question for jabs, and then I got to wrap up. Okay, and then I got to wrap up. And so if those are the last two questions that I'm going to take for right now, and then I've got to get into the Spanish episode. So if you speak Spanish, or if you want to join in Spanish, practice your Spanish with me, then join at 11 a.m. So in just 8 minutes. So worst behavior 811. What if my wife can't do advanced parole because we don't have a humanitarian reason? Okay, this is a great question. Thank you for asking it. And what status does your wife have? Because if your wife has DACA, for example, then there are 3 reasons that work. All right? It could be a humanitarian reason, it could be for an employment reason, or it could be for an educational reason, the travel. All right? I was just meeting with a client that traveled through DACA for a study abroad program, just went for a conference that was educational related in a different country, in Spain, in her case, and then re-entered on advanced parole. So we got to understand the status of your wife, and then we can give her good advice as to whether or not she can get advanced parole. Okay? And sometimes there's more ways to do it. Like she could talk it through, have a consultation, and then we can really see whether or not there's another way to do it, or whether or not this parole in place might work, right? Or whether or not, she's eligible for something else. Jabs, I see your question here. What do you think of filing with no checking account but with 2 credit cards for marriage-based green card as part of my bona fide evidence? It's fine. It's fine. And if you're married, why not open a bank account? Why not open a bank account? It's not a bad idea. If you show joint assets, it's like, okay, now the government's like, okay, you're really married, right? Now you don't have to. It's like, what else then? If you don't have that, what else are you going to use to show to the government, who's always skeptical, always going to kind of be suspicious about relationships? What are you going to do to show that you have a legitimate relationship? Do you have kids together? Are you trying to start a family together? Right? That's the easiest way to show bona fides. And if not, you don't have to, right? If not, what else do you have? Are you paying taxes, married, filing jointly? Are you, do you go to the same gym together? Show a gym card. Do you both have Costco cards? Do you have credit cards together? What else do you got? Right? Are both your names on the same lease? Right? Because, if you don't have a checking account, like, why don't you just create one? Anyway. My philosophy there is, are you married for real? Because if you're married for real, like, share your stuff. I don't know. Maybe that's my own bias. Maybe I'm old school that way. Man, I'm so grateful to be married in a real relationship where I don't have to worry about anything because it's all shared. It's just all shared. It's like I don't have to keep secrets or worry about who's spending what from where because we're on the same page. Anyway. Top 5. If parole in place gets approved, how long would it take to get a green card if I already have DACA? Are you married to a U.S. citizen? If so, adjustment of status through marriage to a U.S. citizen is approximately 2 years, 24 months or less, right? And we got one approved. We got one approved last week that took a little over 1 month. It was like, what? Man, it got approved so fast. So, processing times are in flux right now. I'll say that as well. Ashfaq Gil, and then Juan Ospina, and then I got to move. All right? So Ashfaq Gil, U visas take a long time. I'm from 2018, deported and still waiting. How much longer will it be? Okay, so you filed for the U visa in 2018. You were deported and you're still waiting. How much longer will it be? U visas filed right now are taking over 30 years. All right? We're talking 2054 that U visa will be approved. What? You kidding me? Yeah, I'm telling you the truth. A U visa that's submitted today, if nothing else changes, if current processing stays the same, will be adjudicated in 2054. All right, which is insane. I know it's insane. You know it's insane. Congressmen know it's insane. It's up to them to change it. It needs to change at some point in the next 30 years. So it's a crazy long wait list. The reason it's crazy long is because the law has an artificial limit saying they can only adjudicate 10,000 U visas per year, even though for the past 10 years, there's been 30,000 U visas submitted every year. And so, anyway, that's it. All right. Jabs, I see you there. Go ahead and add a checking account too. If you're worried about what evidence the government will have to demonstrate you have a legitimate relationship, sincerely, it's kind of like the more the merrier, and sometimes you think outside the box, all right? So yeah, create a checking account, use the checking account, because you'll actually, people will be, the government can look at it. And think about what other evidence you might have available too. Juan Ospina, hello, I withdrew asylum at the interview, but I have a U visa bona fide determination. They told me not to expect any correspondence from the asylum office. What happens with my C8 EAD, which is expiring in 2028? I still don't have C14. Okay, I got that. I got that. So what will happen is your C8 EAD will expire, and now that you've withdrawn your asylum, you won't be eligible to renew your C8 EAD. So cross your fingers that your bona fide determination from the U visa comes in, your work permit comes in through the U visa before that date. And if you've already got your BFD from the U visa, it probably will. Okay? It probably will. So you're probably okay. All right? Hope that helps. If you want a lawyer to take a look at it, feel free to contact my office. We'd be happy to look at it. All right, Jason Nguyen, I think the government should consider what you are doing for a living, no need for anything else. I don't know what you mean by that. What you are doing for a living, no need for anything else. I mean, the government will consider what you're doing for a living, for example, when you file for your taxes, things like that. But it depends on the type of case, right? Like if you've got to show evidence of 10 years in the U.S., sure, yeah, you can show the evidence that. I mean, if you're saying, if this is like political commentary, like, hey, the government should allow you to adjust status just based on what you're doing for a living. I mean, that's creative. That's cool. You know, run with it. Go for it. Tell your congressman. That's a cool, creative idea. So, okay, I see that. Jabs, I see your point. Spouse doesn't have an income. That's why we additionally didn't do the checking account. Okay, no problem. Yeah, that makes sense. That makes sense. All right, you guys, I'm way overdue. I gotta stop, but thank you all so much for being here. I really appreciate all of your chat, all of your engagement. I really appreciate it. You know, my empowerment tip that I was going to share is just to say that, you know, immigration is risky. All right? Because everything in life is risky. You know, when I was 16, this was the first time I traveled to another country without my parents. Okay, I went to Spain. I was with a school group. My first day there, my first minutes in Madrid with my school group, my friend and I, we were like, hey, let's go explore Madrid. We got lost. All right, we got horribly lost. It was like 3 or 4 hours now it was like starting to get dark. We didn't know the name of our hotel. We forgot. I was 16. I was totally stupid, right? I didn't know the street that the hotel was on. I was like lost, you know. Luckily, the two of us ran into a small group of our school, and then they knew where to go to get back, and we got it resolved. But it's like, okay, you go to a different country, you immigrate, you go do something you've never done before. You go to a place that you've never been before. You go outside your own comfort zone. There's a chance you get lost. There's a chance something goes wrong. There's a chance that things don't work out the way you expect, right? And yet doing that, you'll learn more about yourself, right? You learn something about yourself. You discover something about how the world works. You discover something that ultimately, hopefully, is useful to improve the quality of your life for the future. Like, immigration is risky. Life is risky. But here's the thing. There are risks that are worth taking. All right? There are risks that you take that, man, they change your life for the better for the rest of time. Right? Maybe immigration is one of those. Anyway, that's all I got for today. I hope this is useful, you know? I hope it's helpful. I hope this whole conversation is useful and helpful. I really appreciate everybody tuning in. If you want more information, updates, feedback about your immigration case or about the status of immigration laws or about this Biden Parole in Place program or whatever it is, please, if you just do me a favor and give me a heart, give me a thumbs up, give me a subscribe, or if you really want to, subscribe to our channel in YouTube. All right, type in Land or Home Immigration. into a YouTube search. We'll come up, hit the subscribe button, hit the notifications bell. You can stay informed as we upload additional videos with additional updates, news, things of that nature. And hey, as always, if you've got an immigration case, if you've got an immigration question about your life, about your situation, please feel free to give us a call. We are here to help. We would love to help. All right? That's all I got, ladies and gentlemen. Thank you so much for being here with me. Thank you so much for your participation. Everybody that interacted with me in any way, I really appreciate you. And yeah, that's all I got. Thank you all so much. We'll see you next time on our next episode of the Empowered Immigrant Live. I'm Otis Landerholm, Landerholm Immigration, A.P.C., where we fight for your American dream. We'll see you on the next time. All right, take care. Bye-bye.